Good afternoon. My name is Attorney Devin Shanley. Thank you for joining me for lunch. Once again, this is Lunch with a Lawyer presented by Peterson, Berk, and Cross. I'm arriving a little early, just kind of keeping an eye on things. If you see me adjust, I'm wearing my glasses today, and I'm just trying to make sure that I don't get too much glare on my glasses so you can actually see my eyes. So a little review about the format for what this is and what we're going to be doing. Uh, First, we're going to be talking about, I'll show my lunch in just a moment. Today's lunch is not quite as, isn't quite as fancy as some others. It's going to be leftovers, but cooking's a hobby, so I don't mind showing off what I'm eating. So we'll be talking about my lunch. If while I'm doing that, you mention what you want to eat, that is great. Please do share because I'm always curious. I've taken to on Facebook lately when I'm cooking and when I'm eating. I'm one of those people that's starting to take pictures of my food, as lame as it is. I always find that food is a social experience. So showing that off is fantastic. Please share. And if you're just catching this afterward, leave in the comments section if you're going to eat with me, even if it's dinner or breakfast, and say, I'm having cereal, eating breakfast at lunch with the lawyer. That's awesome. Thank you. Uh, so we'll be talking about that. Today's topic is going to be a concept called best interest of the child. So I'll be talking a little bit about what that means and how that plays out inside of a primarily family law case, and then I will open it up for questions. Side note, for anybody who is going to ask questions, whether you've submitted them ahead of time, I do have a few here, or if you put them to the comments of the section, which please do. That is awesome. I love it when people do that. No matter which way that goes, then you have a situation. Well, first of all, it's going to be all of our answers are going to be based upon hypotheticals. So at no point are we going to be responding to specific facts with specific cases. All of our answers are going to be based upon hypotheticals. It's not meant to form an attorney-client relationship. If you've got questions on your specific facts, please call us at Peterson, Berk, and Cross. Schedule a consult with one of the attorneys in our family section. That would include myself, Attorney Schlemmer, or Attorney Bowler. If I screwed that up, Angela, I apologize. I always mess up last names like that, and I apologize. So either Attorney Schlemmer, Attorney Bowler, or myself, any one of us would be happy to talk with you about your situation and how we can best serve you. So I believe that covers our disclaimers. Oh, nothing in the answer is attempting to form an attorney-client relationship again. Call us if you want to talk about your specifics. Today's lunch is brought to you by me. Hey, one of the hobbies that I have is cooking, particularly smoking. I like barbecuing. So today I have a little leftover plate I assembled with, there we are, some smoked chicken that I made. There we go. Smoked chicken, baked beans, and Brussels sprouts. Quick tip, underrated vegetable is Brussels sprouts. So this weekend as you're grilling, particularly with a grill, put some Brussels sprouts on and thank me later. You always want to cook them with a dry heat, I find. Best interest of the child. What does this mean? One of the areas of law that I have the opportunity to practice is a guardian ad litem. I mentioned this last week when talking about placement versus custody, and this week it's appropriate as well. I like this area of law because it's an opportunity to really try to find solutions for people that don't really have a say in the litigation, primarily kids in a family case. And the guardian ad litem is really there to investigate what is best interest of the child. So I spend a lot of time reflecting on this. Best interest of the child is one of those phrases of law that is often called a term of art. meaning it sounds like something that you know. It sounds like English. It sounds like something you intuitively grasp, but it's not. It is a very specific definition. It's a very specific thing, and it refers to a very specific, usually standard inside of the law. What drives me absolutely crazy about best interest when talking about it is people come in and they assume it's whatever is best for the child, uh, but it's not. Another way of thinking about this, I was once giving a talk on domestic violence and the law. It was at a workplace. It was my wife's workplace, and we got to this point, and I was trying to explain this concept of term of art and when things are surprising people about what they mean. And I decided to pick on the word marriage. And I go, well, you know, one of my pet peeves in life is marriage. And at this point, I just stopped, and everybody in the room just kind of, it almost felt like the air was getting sucked out of it as my wife is sitting right next to me, and she kind of gives me this look. And I'm like, well, it's not that I don't like being married. It's not that I don't like the concept of marriage or people being married in general. But when we talk about marriage, people often think one thing, but really the word means something else. In this case, I was trying to drive at this concept where people think that marriage is a sacred institution, which it certainly can be. But not necessarily what the government does is really that sacred. That's more of legal connections that bind people together, and a divorce just kind of separates that. Um, Now, that's my own religious bent to it, but it's one of those constant struggles that I have, and it's a fault in our language. The law is a lot of language, and more importantly, it's a particular language that lawyers learn to speak, and they learn to speak that to other lawyers to resolve disputes most often. And best interest of the child is another one of those law terms, those terms of art, those lawyer language things, which seems to mean one thing and really can mean something a little different. So understanding your case and understanding why there are some struggles in your case will revolve around really understanding what best interest means. One more disclaimer to this, if you're watching somewhere other than the great state of Wisconsin, that is amazing. Thank you for watching. More important, my law isn't really going to count for that. I am licensed in the state of Wisconsin. My practice is focused in the state of Wisconsin. To my knowledge, all of our attorneys here are licensed in the state of Wisconsin. So if you are in Michigan or Minnesota or Texas or Hawaii, good for you for being in Hawaii. And I'm sure the weather is much, well, maybe nicer. It's actually pretty nice outside today. But you need to talk to a local attorney about this as well. Some of this might translate over, some of it won't. When we look at best interest factors, we're going to be looking and starting with Wisconsin statutes. The main statute we're going to want to look at is something called Wisconsin Statute 767.41 sub 5 sub AM. And there are 16 factors that are listed inside of this very long statute. Those factors are the following: the wishes of the child's parents, the wishes of the child, the interaction and interrelationship of the child with his or her parents, siblings, or other person who may significantly affect the child's best interest, quality of time that the child has spent with the parents in the past, and any reasonable lifestyle changes that they have made, the amount of quality time that each parent has spent with the child in the past, the adjustment to the child's home, local school, or religious community, the age of the child and the developmental needs of the child, whether the child is physically healthy or the mental and physical health of the child, the need for regular and occurring meaningful periods of placement between the parents, the ability and affordability of public child care services, cooperation and communication between the parties, and if one person is specifically refusing to cooperate, whether each party can support the other party's relationship with the child, including encouraging frequent contact, whether there's evidence of a party engaging in abuse, what the criminal record of either one of the parties are or people that they are living with, whether one party has engaged in interspousal battery or domestic abuse, whether there is a problem with alcohol or drug issues, or as I always call that, AODA issues. Uh, and that's very common inside the legal field. So if someone's just throwing a word around the term AODA and it talks about you, you should probably talk to an attorney. The reports of appropriate professionals and other such factors the court may deem relevant. What does all of that mean? Well, most of the time when I talk to parents, they think, well, best interest is this is what's best for my child. Don't you understand that? And I'm going to say so. I'm the parent. Of course I know what's best for the child. What the lawyer is thinking is these 16 factors. But here's the twist. There's case law that says that this is what's called a subjective analysis, not an objective analysis. Well, what does that mean? What that means is we don't go by what a reasonable child would be going through. What is this average third grader, this mythical child that's perfectly average? I guess they get C grades and stay out of trouble reasonably or something. Really, it's more like what we believe a third grader should be, or a child of that same age, or in that same area, or what have you. But we don't do that in family law. We look at the subjective nature for that particular child. How does this play out? Well, we've got 16 factors that we could list off any number of things that are going to be important. And on top of that, there's also going to be such other factors as the court may find relevant in each case. And then it's based upon that child. So it's going to work out to something very similar to what the parent is going to say, well, this is just works best for my kid. Don't you understand that? There's enough law to back up a court to say that. At the same time, because we're lawyers, whether we're talking about the judge, who's hopefully been a lawyer before, or counsel, either your attorney, the guardian ad litem, or the opposing attorney. Since we're lawyers, what we think is, what are the 76741 sub 5 sub AM factors? How do these facts mesh with that? And then how are we going to twist those facts in any one of those situations for this child in order to come out and say, this is what's best because? As a result, the path starts to become a lot more skewed than what we think is best, and the analysis can sometimes change. It'll also change depending upon which facts that we emphasize. One of the questions that I got ahead of time that I really loved was, Devin, what factors are more important? What's really going to drive this best interest decision? I get this question a lot. The answer is not straightforward. I call that job security. Essentially what the court says and what the law says is no factor is going to be any more important in any given analysis. Meaning, for example, I've done guardian ad litem work for 7 years, roughly. Yeah, 7 years. I am yet to have a case where the factor of the availability of public or private child care services becomes this wholly critical factor. Normally, people figure something out. However, or people live in a city here in Green Bay a lot of times where there's a KinderCare right down the road. You can't just call KinderCare or a different professional daycare, and maybe they have some sort of scholarship program. We can usually figure out something. So that usually doesn't tend to be a driving factor. Could it be? I suppose. Maybe somebody absolutely cannot qualify for one of these sorts of agencies. Maybe they have nobody around and they have to work. At which point, yeah, that's going to be a factor. And the needs of that child, the needs of that family, and the facts surrounding that are going to drive that analysis. So it's going to shift depending upon what's going on in the family. So another question that I get is, well, how do we balance out time between the parents? I mean, after all, one of the factors is the ability to, The need for regularly occurring and meaningful periods of physical placement to provide predictability and stability for the child. Those of you who watched last week, you saw a question that came through that asked about, well, isn't 50-50 just the norm? Well, maybe, but really no on 50-50. Instead, we have this factor for best interest that says, well, the child, one of the factors that the court needs to consider is that the child needs regularly occurring and meaningful periods of physical placement that are going to be predictable and stable. So that child needs to be able to see their dad, see their mom. They need to see that person on a regular occasion and in a predictable fashion. And the more that we can get to that, the better. Does that mean 50-50? There are some courts that really just assume that means 50-50 unless you're going to show me some other factor inside of this list that really drives me to say no. But that's not really what the statute says. This factor could be driven by the parents' jobs, the actual child care support, where the child goes to school, where the child's counselor is. If the child is deeply into a sport, say football, and they absolutely love being in football and they need to be in football, and one school has got a parent, one parent in one town has got a football program that they really have been in forever, and that's where all their connections are, and the other parent doesn't, and the football schedule is driving it, the football schedule might drive it. It might not. It's going to depend upon how the parents and the attorneys are going to be, and at the end the court is going to put in. Hi Julie, thanks for watching. It's good to have you here. I'm seeing if she's watching. So, and if anybody else wants to check in and say you're watching, hello, I will give you a hello as well. But that is really going to drive a lot of this when we start looking and getting into the nit and grit of how do these factors put together. In fact, even as I was putting forward this one thing, you heard about 2 or 3 other put together as well. Hello, Cindy. I'm glad to have another person check in. When we talk about not just when I say, oh, well, maybe it's a sport, maybe that's driving it, then I also talked about connections inside of the community. It's not just connections with the parents, it's also going to be connections with the child's team in that case. Well, they've got this deep connection inside of this sub-community, the football, and now we have that. And now my wife is joined as well. So hello, darling. So we have that. How do we maximize time? One thing that came in last week, I didn't like not answering it, and I almost went back online live just to address it. Typical placement schedules. I always find there's about 3 typical placement schedules that most practitioners around here use to break apart when we talk about shared placement. Shared placement means some sort of form of 50-50. It's what people call either a week on, week off, what would be referred to as a 2-2-3 or a 2-2-5-5. Week on, week off makes sense. That's going to be child spends 1 week with mom, the next week with dad, so on and so forth. Let it flip-flop. Pretty straightforward. 2-2-3 means you spend 2 days with mom, 2 days with dad, and then 3 days with mom, and then vice versa. This works out very nicely when you have a child that wants to have some really regular time with parents. You don't get any blocks where there's going to be a long period away. But that also means there's going to be a lot of transition times, a lot of exchanges, and there's going to be a little bit of unpredictability because you're going to have to figure out which days you're at mom's, which days you're at dad's. It's going to go by the rotation and that feel of how that's moving along, rather than just looking at it and then looking at a calendar and going, it should be there. Another one is something called 2-2-5-5. This is one where it says, well, mom gets on Monday and Tuesday, dad gets on Wednesday and Thursday, and then they rotate every other weekend, Friday, Saturday, Sunday. This is kind of a balance between 2-2-3 and week on, week off. You still get some times during the week, and you still would have some equal amount of weekend time. And you'd have larger blocks of these 5-day periods where a child can really settle in and get used to the structure of this other house. I always also like to use this when the parents are really at odds, because if there's going to be calls to the police, uh, it's a lot easier for a law enforcement official to be able to interpret an order that says, Mom gets Monday and Tuesday, there's an exchange on this day at this time, and Dad gets Wednesday and Thursday, there's an exchange at this time, and it's every other weekend, uh, where it's going to be a lot clearer about where the child's at on any given day, rather than a 2-2-3-3 where you'd have to cross-reference with a calendar and try and show that. But that's a preference of mine. Does that mean we're limited to only those 3 forms of placement? No. We can structure it out any which way we can that's going to make sense for that child and that family. It provides a great opportunity, but you're going to need to be really paying attention to the facts of your life and the facts that's surrounding your child and your family and what those needs are in order to account for that. I got a question also this week. Someone had asked about hearing people talk about quality time versus quantity that would fit into this. Again, the best interest factors don't really touch upon this, but it does in a slightly different way. Again, we're talking about when we look at what that wording says inside of the factors, it says regularly occurring and meaningful periods of time. Meaningful is going to be the word that really drives this. One area that I come across a lot inside of these sorts of situations is this. And if you have school-age children, you probably know what I'm talking about here. Monday through Friday, assuming schools are back in session and we get things back to somewhat form of normal, then Monday through Friday, you're probably waking up your child, getting clothes on them, feeding them breakfast, pushing them out the door to get them to school. Somebody is going to pick them up, depending upon when you get out of work and who that is. You're going to make sure that they do their homework. You're going to once again try to get them to eat some food. You may get an hour or two, depending upon the age of the child. And then it's, okay, everybody has to go to bed. Did you get your homework done? Okay, brush your teeth, put on your pajamas, let's get to bed. And then you repeat until you get to Friday. That means your quality time might not be that high. It might be just an hour or two where you're actually relaxing, spending time with the kid. In that time period, that child might really, really need to get their fortnight in, so you may not actually get to see them much. Or if they have extracurricular activities, that 3 to 8 or 9 period, that 5-6 hour block is going to be filled with driving them to activities, driving them there, maybe trying to go shopping. You also got to take care of yourself and eat, and there's going to be 3 other schedules, and you don't know how you're going to fit this all in. That is life under normal circumstances for so many families. So that Monday to Friday might not really be quality time. Your main quality time might be weekends. Or if you're an over-the-road truck driver and you're on the road from Monday to Friday and you spend weekends at home, you might not literally even see your child. So a week-on, week-off schedule might not make any sense at all. In fact, you might not even have what would be considered shared placement. You might just have something where it's what would be referred to as primary and secondary placement. But you still have more quality time even though you only see your child a couple days a week. That might have been what you were even doing before. So, how hard is it to change? Again, this was probably a question I should have addressed last week, but I think this works here. When we talk about changing one of these things, whether it's legal custody or physical placement, but we'll talk primarily about physical placement. If the order was done 2 years previous, then you would need to show a substantial change in circumstance and that it's in the best interest of the child, which means we go back to these factors, we have a guardian plan to look at it, everybody kind of argues which factors are more important than others, so on and so forth. If it's legal custody, then that's going to be a little bit different. The other trick to a lot of this stuff with best interest is that there is a very small presumption in the law that says the current order is in the best interest of the child, meaning we need to not just show a substantial change in circumstance, but we need to show why it's important to change. What's going on with this child that is making us need to change things, because if we can leave it alone, we want to. That's going to generally be the attitude of the court. They're not going to change just for change's sake, and they're not going to change just to see what's happening. There needs to be a reason. There needs to be a driving force, and we need to try and help the child out. So that covers most, well, actually, there's one more thing I want to touch on that I got in this week, talking about domestic violence. One of the factors, actually there are two factors that talk about abuse and domestic abuse. How does that work with best interest of the child? Domestic abuse in family law is interesting. Primarily, evidence of domestic abuse, in my opinion, is going to have most effect on the legal custody side of the determination. For those of you that recall from last week, or if you watched the other video, legal custody is the ability to make major decisions. This is an area where, as a guardian ad litem, again, teaser for next week, if I'm looking at a case and I start asking questions about, well, how do you communicate? How do you balance out? As much as there are communication questions inside of the best interest factors where that might fit in placement, that's primarily going to be a concern of mine on legal custody. How do these two get along enough where they are going to be able to form a parenting team to make these major life decisions? If domestic violence is present, that's going to throw an imbalance into the ability for these two parents to be able to work together to be a team. In fact, the abuser is probably grinding the victim parent down into the dirt in order to try and just get their way, and that's a problem. We don't want kids to learn that. We don't want them to deal with that. So we're going to shift more power away from the abuser as a result. When we talk about physical violence, there's a temptation by a lot of courts to look at this purely as a child safety issue. Is the child getting hurt by the violence, or is the violence directed somewhere else? If you have a situation, or if there is a situation where there's a child with bruises, there's going to be a very strong argument to limit physical placement of the child. I don't think it's going to be exhaustive to that. I think, depending upon the facts, there's an ability to look at what the child is exposed to as well, to try and understand how does the child witnessing this violence affect the child. Whether or not the child was hit or not, if the child is watching mom hit dad, or mom hit dad, or dad hit mom, or if the child sees that as a baseline for relationships, what are they going to learn, and how is that going to affect them moving forward? And if that's going to affect them negatively, I think there's an argument to be made about how to show and say, look, this is setting a bad example for relationships. This is setting them up to be a violent person, to actually possibly be in criminal danger later. And we can't model this sort of adult behavior for this child. That's inappropriate. If there's going to be a more safe, and there's going to be a more stable and appropriate learning environment for the child, we need to put that child there. It's a little bit more difficult argument to make, and you need the right facts. So if you have a situation like this, you really need to talk to an attorney to really try and understand what is going to be the best arguments to make so that you can argue what you believe is best for your child. I want to leave with this note. One thing that I get all the time from parents is this sort of assumption that I am determining what is best for the child. In fact, one of the questions I got, and I didn't get a chance to formally get to it, was who actually determines this? Best interest of the child, again, is a legal determination. It is an actual term of art that is a conclusion of the court. The judge will make that determination. That's a mixture of law and fact, meaning there are lots of facts that the court would have to find, but as they find those facts, they make a conclusion of law, this determination is in the best interest of the child. So that's going to ultimately be the determination of the court. Now, there is going to be a special lawyer called the guardian ad litem that is going to investigate that. They're going to make their own conclusions as to what is in the best interest of the child, and then they're going to advocate for that. Judge, I think this is in the best interest of the child because, and they'll list out all of the factors that I list. They'll hopefully have a very, very long recommendation where they're going to write a sort of legal brief that will address who this child is, who these families are, what's going on, this is what my facts uncovered, this is what I'll prove in court, so on and so forth. A lot of times I'll have parents come in and they'll say, I'm the parent, I'm the mother, I'm the father. Of course I know what's best for this child. Of course this is it. Don't you want to listen to me? I'm the one who lives with them. I make all the decisions. You need to listen to me. That's it. Well, who are you to say that? Well, who is the judge? The judge is the judge. As a word of advice, even if you're going to represent yourself, never tell the judge who are they to make a determination. It will not end well for you. The same thing if you're going to meet a guardian ad litem and you're going to say, you're just some guy. Who are you to make that determination? That does not endear you to the guardian ad litem. Don't say that. It just doesn't help. It'll make you feel good at that time, but in the end, it'll probably hurt your case. Who are they? They're the legal experts who are trained to make these legal decisions. They need to investigate the facts. You need to present the facts to them oftentimes in order to be persuasive to say this is why this is. And there will be some credence given to parents, but ultimately it's going to be the various parties advocating this to a judge to make this call. So as you're thinking this through, you need to understand the factors, understand how to organize your facts to fit into those factors, and how to be able to make those legal arguments in order to convince a court that it is in the best interest of the child to do what you want to do. Thank you all for joining me today. I know I went a little over, but that was great. I'll even cut down the ahs in the future. If you heard something in this today where you think, I really need to talk to an attorney, consider Peterson, Berk, Cross. We do have a free half-hour consultation, and the family law attorneys here are more than willing to sit down with you. If you're thinking about some other legal issue and you think, wow, this firm is great, they're doing this nice thing, I want to know, please call. We've got other areas of law that we handle, including personal injury and estate planning. So please keep us in mind. And at Peterson, Berk, Cross, we specialize in you.